Thank you so much for spending a little bit of your lunch hour with me today. And I want to thank Cammie Hendricks for taking pictures of those unbelievably photogenic-looking people up there. You really are a beautiful bunch of people. You know, there's a great tradition in this nation, which is mandated by the United States Constitution, holding that the President shall, from time to time, give Congress information of the state of the Union and recommend to their consideration such measures as he shall judge expedient. You know, first presidents just sent written annual reports to Congress, but every president since Woodrow Wilson has taken advantage of this constitutional mandate to address a joint meeting of Congress. And tonight, I, along with a lot of other government history geeks, will be watching and listening to President Obama as he delivers the State of the Union address. It's always been a time to share a philosophy and an aspiration with the nation. There's been some amazing ones, there have been certainly some forgettable ones, but in 1941, FDR outlined the four freedoms, which still hold today: freedom of speech, freedom of religion, freedom from want, freedom from fear. And 8 years later, after World War II, President Harry Truman said the State of the Union is good. 26 years later, Gerald Ford said the State of the Union is not good. In 1996, President Bill Clinton said the era of big government is over. In 2002, George W. Bush said the state of our union has never been stronger. And last year, President Obama said the state of our union is stronger. So I'll be listening tonight for that key word where we try to encapsulate the 300 million people of the United States and the very complex dynamic society that we have into a single word or phrase, because, you know, that's what we do. Last year I decided to borrow this great tradition and start a State of the Office speech. And indeed, it's a challenge to come up with a single word or phrase to describe the important and interesting work that we do here, the amazing work of the 532 people who make up our team. But I have decided on this word for this year, that the state of our office is dynamic. When you look up dynamic, you find these synonyms. It's lively, active, self-motivated, energetic, vibrant, forceful, vigorous. That's us. That's our office. So in just a few minutes today, I want to talk about the work of the four corners of our office, the accomplishments of 2013, and look forward to some aspirations for 2014 and beyond. Our review of our dynamic office begins with a stop in the Family Support Division. The Family Support Division this year launched what we call the Navigator Program, which connects parents who have child support obligations with resources and partners in the community that provide education and training and employment. The division has new partnerships with Pioneer Human Services, South Seattle Community College, Goodwill, the Fair Start restaurants, and many, many other groups that are trying to help people in our community. We're trying to help people become independent and self-sufficient, people who desperately want to provide for their families. The Family Support section has taken its services to courtrooms throughout King County, including the Mental Health Court, the Veterans Court, Drug Court, and even in our LEAD program on the streets of Seattle. Now, the division collects about $200,000 every month in unpaid child support through its contempt of court and other child support diversion programs. But our interest is not limited to collecting money. Nor is it useful for us to simply collect paper judgments that are uncollectible in the real world. Instead, our new direction is aimed at helping people who are struggling with supporting their children to step up to that most important role that any of us will ever have, that of a responsible parent. Now, over in the Civil Division, we helped county clients with a number of major projects, such as the purchase of the East Side Rail Corridor, the reconstruction of the South Park Bridge, and planning the construction of the new Children and Family Justice Center. Civil Division lawyers also helped negotiate an agreement between the county and the city of Seattle and Chris Hansen for a new basketball and hockey arena to be built in Soto to bring the Sonics back. We also successfully defended against 2 lawsuits challenging that agreement. Now, I'm confident that someday the return of the Sonics will happen. And when you enter that arena and you await the tip-off, remember that this game was brought to you in part by your civil division. Now, the civil division also helped reduce the payout in tort lawsuits against the county in 2013. Payouts totaled less than 1/4 of the payouts for the 2 years previous. In the workers' compensation arena, we helped the county reduce claims by $3 million in 2013. King County, like our Seattle Seahawks, each have a tough defense. In 2013, the civil division, like the Hawks, proved stingy in the red zone. Sadly or not, this is my only reference to the Seahawks in today's speech. 2013 was also a dynamic year for innovation in the criminal division. Well, I could easily talk about the contribution of every unit, lawyer, and staff member here. I have to, in the interest of time, talk about a few prominent examples. We start with the district court unit. They met the challenge laid down by the legislature to rush file more DUI cases. In fact, the filers have been absolutely prolific. They've filed 9,600 cases last year, which is 2,700 cases more than the year before, and 3,500 cases more than the year before that. And not only were they filing like mad, but district court unit deputies, where DUIs is about half of our total caseload, conducted a record 220 jury trials in 2013. Now, a regular highlight of my day is to stand up in my fourth-floor office and look down into Judge Harper's courtroom in Seattle District Court. And there I get to see our district court unit deputies doing what they do, arguing motions, selecting jurors, questioning witnesses, doing sentencing calendars. And I enjoy watching you. It's okay. You don't have to wave back. But that is where it's happening in district court unit. You could not talk about 2013 in the criminal division without uttering these three letters, PBK. Not PBJ. I still have a fondness for PBJ, but PBK, after 3 decades of using the PROMIS system, we have migrated to the prosecution by carpel, or PBK system. You know, change is hard, and technological change may be the hardest of all. PBK, while it is still a work in progress, is already proving to be a success, and it will revolutionize our practice. It will give us instant access to microdata and macrodata and things we could only dream about with the mainframe PROMIS system. It will also take us one step closer to the reality of the paperless discovery process, where no longer do we have staff standing at photocopiers all day long, turning forests of paper and oceans of toner into stacks of discovery. Someday that will all be done with a few clicks of the mouse. The PBK progress has been because we have such a dedicated team, and I want to take special note and thank each and every person who has worked tirelessly for hours on this very important shift, probably the most significant thing that we've done in the criminal division in terms of our internal operation in decades, is to migrate to this new system. Other places like Honolulu and Maricopa County and Phoenix, Arizona have, since we joined PBK, have also contracted with them. So they're counting on our success to be part of their success, and I know that it will be a success. In the domestic violence unit, I want to note that our protection order advocacy program turned 25 this year. We served 5,000 people just this year alone, over 100,000 in the last quarter century. People living in fear of intimate partner violence who came in, who summoned the courage to come into our offices and ask for help. And there they were met by caring and wise advocates who helped them through the mystery of the protection order process. Didn't matter if there was an arrest made in their case, didn't matter if there was a criminal case. People who need help get it. They get it in our protection order program, and they've been getting it for 25 years. We also have an amazing team of legal advocates who come alongside victims during their darkest days and their most trying times, working on safety plans and helping them through the difficult plan of the path of the criminal justice system. In domestic violence, we also know that strong laws have made a difference. our efforts to change state laws regarding strangulation, making that a felony, and also a felony scoring for misdemeanor repeat domestic violence crimes. Those have made a big difference in our ability to hold recidivists more accountable and to keep victims safer. Our domestic violence team is also working with our CCAP part of our jail, our day reporting center, on a new pilot for domestic violence batterers, offering a cognitive behavioral therapy outcome of a misdemeanor case as an alternative to the traditional batterers treatment program. You know, we have great leadership in our office in domestic violence, and the keys to building an effective community response is to recognize our role and how it fits in with the greater community response. To work in partnership with organizations that are dedicated to victim safety. And I think the most important thing is to help educate our youth, to grow up with a new attitude where violence and intimidation against ones that you love is not only unacceptable, but unthinkable. In the Special Assault Unit in 2013, we saw a new emphasis, the fight against the commercial sexual exploitation of children. Working with new laws and new partners in law enforcement, we have filed over 50 cases against men actively soliciting sex from underage girls on the internet. We're the only office in the state to actively focus on the demand side, using the internet, which has up until now carried virtually no risks for men looking to exploit young girls. You know, people will tell you, maybe out of habit, that there's nothing that we can do about prostitution. It's the oldest profession in the world. That's not true. The oldest profession in the world is slavery, the selling of one human being to another. We know too much about the violence and the damage done to young people being rented for sexual abuse to disregard it. We know too much. Squeezed in between the sadistic and manipulative pimps and the predatory violence of sex buyers, these young victims of commercial sexual exploitation are trapped in a living hell, and it's happening right here in our own community. The commercial sexual exploitation of children is anything but a victimless crime. We look forward to the day that our community rises up and says, we're better than this. No more in our community. And we will have been leaders in that fight. I look at the work in 2013 of the Havoc and the MDOP crew. You know, we continue to take tough cases to trial and win them. We just win them. And it makes such a difference. Each tragic murder creates waves of grief throughout our community, and the ability to resolve a murder case with a verdict of guilty and with a sentence that protects the community, that brings a postscript of justice to a family that will suffer that trauma for the rest of their lives. It also protects us from people who would perpetuate random and irrational violence. And I have a special appreciation for our MDOP prosecutors who are on the front lines of tragic violence. You know, every day, one of them is carrying the cell phone and waiting for that call. And they may be called to witness a scene and to witness violence up close and personal, to witness scenes that none of us will ever have to see. I'm proud to serve with such dedicated and outstanding public servants, and I'm proud to be in an office where being an MDOP lawyer and being on the Havoc unit continues to be an aspiration of the young attorneys who come on board, to continue this service, continue this record of excellence. At Juvenile Court, we have implemented a new staffing model that reflects our new reality there. You know, our cases are way down at Juvenile Court. We went from about 8,000 a year to about 1,800 last year. But the cases that are left represent some of the most complex and dynamic cases that we have anywhere in the office. The social and criminal issues involved in those cases require a certain level of sophistication and maturity, and we have a new staffing model that reflects that. You know, we complement this approach to serious youthful offenders with the continued success of our 180 program, which is a diversion program for minor offenders, in which last year we diverted more than 300 youth out of the criminal justice system into a caring community. If you haven't been to a 180 program yet, you are invited. We have them one Saturday a month. and they are something where we have a role for prosecutors, and if you want more information, talk to Lisa Mannion here up front, and we'd be happy that you would come and watch and maybe come participate. We also continue our strong efforts to keep kids in school with our truancy team. With what we know about the direct link between school failure and crime, we can hardly give up here. Did you know that 6th graders who miss 20 days of school in a year have only a 20% chance of graduating from high school? Clearly, our efforts to keep kids in school cannot start too young. We know that high school dropouts are 5 times more likely to go to prison during their lifetime than high school graduates. If you drop out of high school, you're 5 times more likely to go to prison than if you stay and graduate. That is an amazing statistic, and it energizes our team every day to go throughout the county, not to bring kids to court. We want kids in class. And so what we do is we set up a series of attendance workshops throughout the county in every school district that we operate in, where we engage students and parents and the school to recognize the value of education. Clearly, keeping kids in school is our best crime prevention strategy, and we're on the front lines of that fight. There's so much more to talk about and so little time, so I have to speak in acronyms for a moment. 2013 was a great year for the VECU at the MRJC, the CTR and the RBI and the FTU and the ECU did amazing work. In addition, we're very proud of our mortgage fraud unit, our elder abuse unit, the mental health court, and the Veterans Court, which is part of the mental health court. Veterans Court just finished its first year of full operation. Contrast that to drug court, where this year we will celebrate our 20th anniversary. And we continue to bring more and more complex cases before our drug court treatment program. The LEAD program, our street-level drug diversion program, is 2 years into this great experiment, and it will now expand beyond Belltown into the rest of downtown. The King County Prosecutor's Office Brady policy became statewide Brady policy this summer when the rest of the prosecutors voted to adopt it. And our appellate unit won important cases this year, arguing in the Supreme Court to overturn trial court opinions that threw out the death penalty. These unanimous decisions of the Supreme Court helped push these cases back toward trial, where a jury will one day finally decide the crucial issues at stake. We have indeed built a strong team to fulfill our mission. The state of our office is dynamic. We are all about the vigorous pursuit of excellence in our mission to do justice. Yet, while we are justly proud of our office, we must acknowledge that criminal prosecution function across the United States has come under heightened scrutiny in the last few years. Throughout the United States, in academia, in media, and on the street, prosecutors have come under criticism for the way that they have exercised power. Now, we found this out locally when I approached our 2 law schools in town about the idea of starting a prosecution clinic. We heard loud voices from both faculty and students echoing this criticism that they had read nationally about prosecutors who lost sight of their mission to do justice. And on campus, we were confronted with issues and objections based on the phenomenon of mass incarceration, of racial disproportionality within the criminal justice system, and with high-profile examples of prosecutors who had abused their power. There's no doubt in my mind that our role and our office are misunderstood and misrepresented on campus. But I'm pleased to report that our office and the University of Washington Law School have agreed to partner and create a new prosecution clinic that will start next fall. And I'm also pleased and excited that Rich Anderson has been selected to be our first clinical instructor and also help design a seminar on the prosecutorial function. He will be a great representative of this office, not only helping law students to develop trial skills that they need, but to understand the power that we wield and the processes that we employ to accomplish our mission to do justice. As we look at criticism of prosecutors around the country, I find it helpful to remember our office mission statement, which today celebrates its 1-year anniversary. Those of you who get business cards will, someday in 2014, get business cards that have on the back of them our mission statement. Because while I'm not a big mission statement guy, I really love our mission statement. And I think it is the recipe for us to remain the finest prosecutor's office in the country. If we all abide by this, then we cannot go wrong. The first line of our mission statement is, the mission of the King County Prosecutor's Office is to do justice. Well, that seems kind of simple, but it's also profound. The situations where prosecutors overreach and where they abuse their power is when they decide that winning is more important than doing justice. Now, much of the criticism of our profession revolves around excesses in the federal system, where stories like this from the New York Times last month. The headline said, "Mandatory sentences allow federal prosecutors to squeeze pleas from hapless defendants at the cost of doing justice." Prosecutors routinely threaten ultra-harsh, enhanced mandatory sentences that no one, not even the prosecutors themselves, think are appropriate, said Judge John Gleason of the United States District Court for the Eastern District of New York. "The way prosecutors use this hammer," Judge Gleason wrote, "coerces guilty pleas and produces sentences so excessively severe that they take your breath away." A study by the Human Rights Watch in New York quantified what they call the trial penalty in the federal system, the extra prison time that federal defendants get if they exercise their right to trial and lose. In 2012, drug defendants who pled guilty received an average sentence of 5 years and 4 months. But those who demanded a trial received sentences that averaged 16 years, triple the sentence of those who pled guilty. Not surprisingly, 97% of federal drug defendants plead guilty. The crescendo of criticism about the abuse of the federal prosecutor's power overreaching their goal of doing justice even resulted in a speech by their boss, Attorney General Eric Holder, who told the ABA last year that he was calling for a fundamentally rethinking drug sentencing, saying that many low-level, nonviolent drug offenders should not be charged with offenses that impose draconian mandatory minimum sentences. It's true, the federal prison population has exploded in this country. Over the last 30 years, we went from an average of 25,000 federal inmates to today's 220,000 federal inmates. And Congress, for the first time, is considering serious sentencing reform because the Bureau of Prisons budget now consumes a full 1/3 of the Department of Justice budget. And over half of federal inmates are serving time for drug offenses only. Contrast that with 8% of prison inmates in the state of Washington. But the criticism goes beyond drug cases, and it goes beyond federal prosecutors. Concern over the concentration of power in the hands of prosecutors is shared here in our state as well. I read as many books as I can and articles as I can of criticizing the prosecutor not because it's fun, but not because the criticism is always accurate. It's not fun and it's not always accurate. And it doesn't always relate to us. But I know that others are forming their opinions about us based on what they read. And I also know that as good as we are, we can benefit from asking ourselves if the power that we exercise is in harmony with our stated mission. The second sentence of our mission statement reads, "We exercise the power given to us by the people with fairness and humility." Now, these words were chosen with care. Rarely do you see the words power and humility in the same sentence. But we respect the power given to us by the people, and we desire only that it be exercised fairly. That sentence reflects the tension that we know is present in our justice system. Our justice system is an adversarial system, but it's a unique form of an adversarial system where the prosecutor has to exercise not just power, but also restraint to accomplish justice. Our institutional tension is this: We are responsible both for the safety of the community we serve and ensuring a fair outcome for the people who have been charged with criminal conduct. We protect the rights of victims and defendants. One concept I want to mention today is what I call the maximum justice value, the maximum justice value of a case. And by that I mean the notion that every criminal act deserves a consequence that falls within a range of punishment that is proportionate to the harm caused to the community by that defendant. There is, however, a tendency in all systems to lose sight of the underlying conduct as the measurement of the harm to the community, and instead punish defendants according to the extent of the process necessary to hold them accountable. Now, prosecutors often respond to that kind of criticism by saying that we need this leverage to obtain plea bargains with clearly guilty defendants. It's a sound way to conserve our resources and obtain cooperation. Besides, they say, these outcomes at trial, they're all outcomes that are perfectly legal, that are authorized by the law. That's true. Here we try about 8% of our cases in this office. It's a very healthy trial rate. It's a very high trial rate. And there is no way that we could realistically operate a system that tried much more than 8% of the cases. Our conservative filing approach is designed to apply the appropriate label up front on criminal conduct, and we expect defendants to plead guilty, to take responsible for their conduct, and plead to that initial charge. In plea negotiations, we do identify other charges that could be added for trial as a way to convince defendants that their best offer is an early plea before that trial date is set. Defendants who refuse to accept responsibility for their conduct, defendants who put us to the test of trial, may well face additional charges and a longer recommended sentence upon conviction. There's nothing new about that, and there's nothing wrong with that, unless the result overwhelms the principle of fairness. The cautionary principle of the idea of a maximum justice value means that there can be a perfectly legal outcome where the sentence arrived at by law is still disproportionate, that the penalty inflicted upon the defendant by law is still greater than the harm caused to the victim and the harm caused to the community. This fall, 2 experienced senior deputies handled a case that involved 2 men, co-defendants, who were responsible for a financial scam where they stole several $100,000 of public money. The man most culpable for this scam pled guilty and agreed to testify against his co-defendant. The co-defendant refused all reasonable offers and made us go to trial. Now, he was convicted, and under the law and under our normal practice, the man who went to trial would face the higher end of that standard range, and the man who pled guilty and testified would face the lower end. This could have been another example of how the process of achieving criminal accountability factored more heavily in the sentencing outcome than the actual criminal conduct. It could have easily resulted in the lesser actor receiving a greater sentence than his more culpable co-defendant. But I was happy to see that our deputies recognized that. They recognized that justice required them to look back at the relative culpability of the co-conspirators, not just the hassle that one of them had put them through to achieve a conviction. And they concluded that we should recommend proportionate sentences for each defendant according to the role that they played in the crime. And we should never lose sight of the target of our justice. It's possible to go to trial and still recommend something less than the maximum sentence. It's possible to decline to add every conceivable additional charge and enhancement if the defendant decides to go to trial. And what would happen if we identified the maximum justice value of a specific act of criminal conduct up front and consciously worked not to exceed it? We should ask ourselves if, in this measured approach, that prosecution would look stronger, not weaker, to the community that we serve. Now, I recognize that exercising power with restraint is something that we do here every single day. It's not easy. If it was easy, anybody could do it. And it doesn't come naturally to other offices. But power plus restraint equals justice. Prosecutors have the power to make decisions that impact people's lives. They naturally and appropriately then become subject to scrutiny and criticism. Some of that criticism is fair and some of it's not fair. Most of it is directed at offices less sophisticated and nuanced in the pursuit of justice than ours. We can't fix the federal system, we can't fix other offices, but we should understand the criticism, and we should be on guard to avoid replicating mistakes that have fueled criticism of the prosecutorial function. I think we're all proud of our office, of our history, of our mission, and of our culture. Whether you've been here for 1 year or for 30 years, I hope that you have recognized that we have something special here. And I hope that you recognize that together, as one, as an office, and as a community, we have the power to shape a criminal justice system that best reflects our ideals, that best reflects our values. And if we truly dare to be different in this office, we will recognize that just because you can do something doesn't mean that you should. And just because an outcome is legal does not make it right. Our best asset in this mission is you. This collection of people dedicated to our mission statement is what separates our dynamic office from most others. So I say going into 2014, let's dare to be different. Let's invite that conversation. Let's invite that criticism about the prosecutorial function. Let's invite that into our office, and let's become conversant with it. Let's embrace our obligations to truth and to fairness and to justice. That's what separates us from other lawyers, and that's what makes our jobs fun and rewarding. Let's keep open minds about truth, about the truth of the charge. Let's keep open minds about claims of innocence, even long after the verdict is over. We can be known as an office that is tough when that is called for, but also an office that knows mercy. We can be known as outstanding trial lawyers, compassionate advocates for victims, and as reformers dedicated to the continual improvement of the criminal justice system. This office in 2014 and beyond will represent the highest standards of our profession. And each of us must share this vision. The vision that there is no finer office in the land than the King County Prosecuting Attorney's Office, that we are leaders, that we are creative problem solvers, that we are part of a larger community that is eager to partner with us, and that we are ministers of justice. I'm confident that this year and beyond, that together we will build a criminal justice system that our county's namesake, the Reverend Dr. Martin Luther King Jr., would be proud of. Together we can be the change that we want to see in our criminal justice system. I'm so honored to be part of this dynamic office and so excited to be part of its past, its present, and its future. Thank you very much.